Hello, everybody, and today I'm going to talk about the legalities of starting a nonprofit corporation here in the state of Florida. So everything I'm going to be talking about, while it may be similar rules and regulations in other states, is specifically aimed to Florida nonprofits. And before we get started, everything in this presentation is meant to convey general information to those interested in starting a nonprofit. And nothing is meant to provide any specific legal advice or opinions. So if you need some legal advice, or if you are interested in starting a nonprofit, please talk to a qualified attorney or financial advisor or tax professional to let them know your specific situation before relying on any information. And hopefully here at Legal Aid Service of Collier County, we will be able to assist you. At this time in January 2021, we are representing nonprofits and those interested in starting a nonprofit free of charge, as long as the nonprofit serves the low to moderate income community. And that is measured at up to 140% of the area median income as defined by HUD. So if your nonprofit plans to provide those kinds of services to that type of community, then we will be able to represent you free of charge. And that would include helping and filing the articles of incorporation, the bylaws, applying for tax exempt status with IRS, corporate governance training to make sure that the board understands what Florida law is going to require and IRS regulations will require to maintain tax exempt status, and just generally how to run the nonprofit ethically and legally. Registering for solicitations of contributions if you plan to solicit funds from the state of Florida. Different nonprofit policies that oftentimes are either helpful for the board of directors or donors or large grants will want to see a nonprofit have. Contract drafting, review, and negotiation for any agreements that your nonprofit enters into. Commercial leases if the nonprofit plans to lease a commercial space. We do Florida trademarks and can provide advice and counsel about federal trademarks. We can register a fictitious name or DBA name. We also do mergers, financial transactions, real estate closings, and dispute resolution, depending on if your organization is involved in any dispute. So that can just be as simple as negotiation with a third party or trying to at least come up to some amiable solution between you and another organization or individual that might be involved in a dispute. So in other words, we're going to talk about most of these issues today, but what we try to do for our eligible nonprofit clients is really try to address any matters that come up that are legal matters and resolve them on behalf of the nonprofit. Or alternatively, if you're a new nonprofit, get you started on the right path so that instead of spending your money on legal fees, you're able to spend those funds serving the community at large. So today we're going to run through what typically we at Legal Aid do for our clients when they are interested in starting a nonprofit. And that is first filing the articles of incorporation. Second, it is drafting the bylaws, which are the corporate agreement. Third is obtaining an EIN or taxpayer number. Fourth is obtaining tax exempt status with IRS. Then we'll talk about briefly nonprofit tax returns that will have to be filed regardless of any income or activity of the organization. Then the Florida solicitation of contributions filing for nonprofits seeking solicitations of funds in the state of Florida or any other state. Then briefly touch on board of director requirements, property and sale tax exemptions, and lobbying for nonprofits. So the first thing when you're starting a nonprofit you'll need to do is file the articles of incorporation, and that's filed with the Florida Secretary of State Division of Corporations. And this filing incorporates your nonprofit and it gives you all of those limited liability protections. However, to qualify for tax exempt status, this document will not do that for you. This just gets you to be a nonprofit organization in the eyes of the state of Florida. So we'll talk about next steps in a few slides how to get that tax exempt status. But if you are eventually going to apply for tax exempt status, you do need to anticipate including some provisions in your articles of incorporation. So for example, if you want to qualify for 501c3 status, the most common tax exempt filing, the organization will need to include some statements about purpose and dissolution in the articles of incorporation. And I stress this because sunbiz.org, the Florida Secretary of State's website, has an electronic form that nonprofits starting out can fill out to file their articles of incorporation. If you're only interested in becoming a nonprofit in the state of Florida, likely that form is going to be fine. But if you want to receive that tax exempt treatment from IRS, that electronic form will not be fine, and you will need to have a paper filing that includes some statements that are not in the electronic form. So again, that's about including purpose and clauses about dissolution, which are not on that standard electronic form. And the filing fee to do this is $70. So the nonprofit should have that money raised already. And they have to renew it annually with what's called an annual report between January and May 1st each year, and that costs $61.25 for nonprofits. Once we have the legal status recognized by the state of Florida, we can start to draft the bylaws. And the bylaws are also an important document, not just to govern how the nonprofit's going to be run, but also if you are applying for tax exempt status with IRS, the IRS is going to want to see some clauses in your bylaws. So the bylaws are the internal operating agreement detailing procedures for operating. And typically they're pretty lengthy because it's trying to address every situation that might arise. And the bylaws are going to be particularly important if your board gets involved in a dispute, if you're trying to remove a board member, if you're trying to hire somebody, if you're trying to enter into a financial transaction. All of that should be contemplated in the bylaws so that the board of directors isn't trying to figure it out piecemeal as it's happening. So it is really important to take the time to sit down and read your drafted bylaws and understand them before signing them. So mostly the bylaws is going to be requirements under Florida statute for nonprofits. And when we draft them, we also recommend some best practices for nonprofits in them. So items that the bylaws should typically discuss will be who the board of directors and officers are, their number, qualification, how they're elected, their term of office, how they can resign, or how they can be removed. Additionally, when, where, and the notice for annual, regular, and special meetings. It's best practice for Florida nonprofits to hold meetings every year, but that's very rare that a nonprofit only board of directors just starting out would ever only hold one meeting. As you're getting started, it's probably more. And to be able to recruit a board and also let them know exactly what they're signing up for and getting into when they join the board, it's best practice to include when, where, and how they'll receive notice for meetings and where they'll be held. And of course, you can have a provision that these meetings can be held electronically over Zoom or video. Also should discuss the right to establish committees and hire paid staff. You don't want to start a committee or hire an executive director or a receptionist and then find out that a board member has a problem with it and your bylaws were silent on it. It should just be in the bylaws that the board has that authority. It should also discuss indemnification for board members. Indemnification for a board member that's serving a nonprofit just means that they generally wouldn't be held personally liable for any actions they take while serving on the board of directors for the nonprofit organization. And finally, procedures for agreeing to contracts, loans, how to write checks, how to make a deposit. For example, it's best that two people are signing off and writing checks over a certain threshold for the organization to make sure that there's some checks and balances there. So again, it's a bit of a lengthy document. Ours that we produce for our clients average 25 to 30 pages. So we want to make sure we have everything resolved in the bylaws before any issues arise later. Third, The nonprofit should obtain an EIN, which is the Nonprofit Taxpayer Identification Number from IRS. And this is a short online process and doesn't have any filing fees. And I emphasize that because when you Google IRS EIN, the first several pages that will come up are actually companies that will charge you to obtain the EIN. And that's not actually through IRS. IRS doesn't charge any fees, and this is likely something you wouldn't need to hire a company to do for you. So make sure that you're actually on the irs.gov website when you're filling out this application to obtain your EIN, and you get it online instantly. After you have that tax identification number, you need to, if you plan to, obtain tax exempt status. Not all nonprofits have to have tax exempt status, but it's usually for the overwhelming majority quite a benefit. And I mentioned it before, but stressing again that being a Florida nonprofit, so taking every step 1 through 3 that we've discussed before this, does not mean that your nonprofit is tax exempt. It means you have a nonprofit corporation in the eyes of Florida, but not that you have tax exempt status in the eyes of the IRS. So you must apply with IRS, and the point of the application either is to show that the organization is worthy of receiving this special treatment as a tax exempt organization. So you're going to have to provide a lot of information showing that that individual reviewing the application at IRS should just easily be able to say, yes, this organization shouldn't have to pay taxes because of the work that they're doing. So the most common filing for our clients are 501c3s. And so I'll focus on that for the 2 choices for filing. So if you plan to be a 501c3, you can either file a 1023 EZ application or what's called the 1023 long form. If you're going, it's really going to be important that you're realistic about what the nonprofit reasonably anticipates at the time of filing, what it reasonably anticipates revenues will be for each year in the first 3 years. If you are expecting some kind of grant or a large donation that would put you over that $50,000 each year threshold, then the EZ application will not be for you. If you hope to have over $50,000 in the first 3 years, that's great, but you may not have to file the long form. If you do not reasonably anticipate at the time of filing, you may be able to file the EZ form. And the EZ form is easier if you are planning to be a smaller local-based nonprofit. If you plan that you're not going to have a large number of assets, if you're not going to be applying for any large-scale grants, it's an easier application. It has a much smaller filing fee, much shorter wait time, and it requests a lot less information. And I want to note that in rare circumstances, some grantors will only consider giving grants to nonprofits that have completed the long form. So that's the drawback of the EZ. It's only $275 filing fee. You'll hear back in just a couple of months instead of like 6 to 9 months. It's really short. You're not going to have to spend a lot of time writing out a lot of information or coming up with lengthy financial statements. But if you are planning to go for large grants and you have a specific one in mind, or you're looking in whatever mission field that your nonprofit is in and you see, oh, here's this really great grant, but they only give grants to those who have submitted the long form, then maybe the long form is more appropriate for you. And this is really something the board of directors should spend some time going back and forth over. In my opinion, this was more common several years ago, where grantors were only interested in nonprofits submitting the long form. But I think it's really easy to also show a proven track record that if an organization did submit the EZ form, which doesn't require as much information to IRS for them to review, we have social media, you have your website, and you have newsletters. You have ways to show about the work you've been doing, and it's not just so much what is in the 4 corners of your 1023 application anymore. but I still bring it up because clients should still be aware that some grantors want to see the easy or the long form and not the easy. And the reasoning again is because the long form requires much more information for IRS to review than the easy. So IRS had to look at more information to decide the organization was worthy of tax exempt status. But if you do anticipate filing the long form, you need to anticipate that revenues will be over $50,000 for each year for the next 3 years, or you plan to go for a grant that requires the long form filing. The filing fee is $600. The wait time currently in January 2021 is about 8 to 9 months. And before you go to submit this documentation needed for the 1023, you really should have a business plan ready. The long form is going to ask a plethora of questions that will frustrate new organizations because you're not exactly sure what activities you're going to have perhaps, or you're not sure what your financial statements are going to be, your budgets are going to be for the next 3 years, but this is all examples of information the long form is going to require that the easy form does not. So at a minimum, questions that the 1023 long form will ask, you'll need to be able to discuss past, present, and planned activities of the nonprofit as it relates to all the activities that are or will be offered, who conducts these activities, what percentage of the nonprofit's total time is allocated to each activity, how it's funded, what percentage of the nonprofit's overall expenses are allocated to the activities, and how the activity furthers the exempt purposes of the organization. So again, a lot more information, but your board may decide, you know what, we plan to go for these major grants. We think that we're competitive and qualify, or there's this grant we want to apply for in a few years, and it says it only will consider those that submitted the long form. I did a little quick search. I couldn't really find any, but again, it's going to depend what area your nonprofit is in. If you're in a specific area that serves meals to the homeless, there might be a grant that says, you know, that it will only give it to organizations that submitted the long form. But if it's something more niche, like an equestrian center that caters to children with disabilities, and you're looking through all the potential grants you might be able to get, and you don't see anything, then it might depend if the easier long form is better. So just will take some time and discussion. And if you have any questions, we have a great kind of cheat sheet we prepared for clients with just general information comparing the two, the easy and the long form, so the board has the information to consider and discuss before deciding which one to apply. Before providing financial information to IRS, there are a few things to consider. This presentation is aimed at new organizations. So for most of you, if you have under 1 year tax year completed, you're going to need to create a total of 3 years of financial information for the 1023 long form. If you're submitting the easy, you won't need to worry about this financial information. So that would include the current year and the 2 future years, and you'll have to provide reasonable and good faith projections for future financials. And this is really what trips up a lot of new nonprofits. It gets really frustrating because the obvious question is, well, how am I supposed to know what my financials are in 3 years from now when I haven't even started? But it's something you'll have to, do your best in a good faith effort to estimate. If you have completed at least 1 tax year, but less than 5, the requirement increases to 4 years of financial information. If the nonprofit's completed over 5 tax years, you'll have to provide financial information for the 5 most recent tax years. And while waiting for tax exempt status, because again, this could be for the easy, it's a couple months. For the long form, it can be up to 9 months we're seeing right now. It's very difficult to estimate. It really just depends how much IRS is backed up, and sometimes the change of administration can cause some delays. But while waiting for tax exempt status, if you do have donors, if you do have people that want to donate money, or you have a large grant coming in, you can ask another organization that's already has its 501c3 status to serve as what's called your fiscal agent. And a fiscal agent can accept donations on behalf of your nonprofit but using the tax exempt status of the other nonprofit. So typically you should have a fiscal agency agreement that outlines that relationship, and sometimes there's a small 3 to 5% fee charged. Other times the fiscal agent doesn't charge anything, and that's more likely when they share the same mission or goal, or a related mission or goal, and they just want to help out another new organization starting. But just letting you know that there is an option to be able to accept tax-free donations if you have another nonprofit organization willing to serve as your fiscal agent while you wait for the decision from IRS. Then you'll need to consider how and what you'll file for your nonprofit tax return. And all 501c3s must file a 990 return with IRS, regardless of activity or inactivity. So a lot of times we'll have a nonprofit that starts something, they incorporate, but then COVID happened or board members got really busy and the nonprofit didn't do anything for a year. That doesn't mean that the nonprofit doesn't have to file a 990 return. The best practice and rule of thumb is it should be filing one every year. There's 3 options. The first is the 990N, or what's commonly referred to as the e-postcard form, and that's for nonprofits with gross receipts of $50,000 or less. Or the 990EZ if gross receipts are over $200,000 and assets are over $500,000. And then for any others, the 990 will be the appropriate form. And again, you can get these all on irs.gov, and they all come with a really helpful instruction sheet. Don't ignore the instruction sheet if you're filling this out, especially the first time without a tax professional helping you. But most nonprofits, if they can, will outsource this work to a tax professional to fill out. But if you can't, and the nonprofit doesn't have those funds right now, the 990 instruction form is very helpful. The 6th thing that a new nonprofit will need to do is consider the Florida solicitations of contribution filing. You may not have to, but may have to register to solicit funds in Florida with, it's kind of random, but the department is the Florida Department of Agriculture and Consumer Services. So if you're going to raise money in the state of Florida, that's where you register here. If you're going to raise funds outside of the state of Florida, say you have a large donor in Wyoming or New York or Illinois, then you may have to register there as well in whatever their relevant department is. And it's required by most organizations soliciting funds from the public. So you don't need this if your organization is going to be solely relying on grant funding, but if you are getting it from the public, you will need to fill this out. Some exemptions, for example, generally don't have to apply if you're a religious or educational or political group. So it's best to discuss with an attorney if you are one of those exempt organizations. And really the information is brief and simple. You'll have to disclose the name of the organization, the state or of its principal place of business, and a description of the purposes for which the solicitation is being made. So financial statements may be requested, probably not, but the point of this is just to keep the state of Florida aware that you're soliciting funds here. And then once you've made this filing, anywhere where you have a donation button on your website, on your social media, or if you send out a letter, it should have a disclosure policy next to it. And at the bottom of the screen, you'll see a sample disclosure policy. And it just has a copy of the information of the registration, where it can be found, and where you can call or visit to obtain more information. And then a couple other considerations for nonprofits that I get as sort of my most common questions from clients. And we'll talk briefly about the board of directors requirements, property and sales tax exemptions, and lobbying. The board of directors must have in the state of Florida at least 3 non-related directors. So if you want to start a nonprofit and you want to start it with your brother and best friend, that's not going to work because 2 of you are related. If you want to start it with two other people that you're not related to, that's going to be okay. And the reason is IRS considers related board members to not be completely independent and a conflict of interest. So even if you have the best intentions and you want it to be family members, the IRS isn't going to see it that way, and it's a major red flag. Once you have your minimum 3-person board, we recommend to our clients that directors should not receive compensation. There are exceptions to that, but really a nonprofit is formed to serve a public benefit, and payments to board members are generally frowned upon by donors and funders, and the IRS strongly recommends against it. So if you do have any board members that are being paid, it will be a red flag on your 1023 easy or long form application. And again, the point of a nonprofit is to serve a public benefit, and board of directors should be volunteering their time to further that mission and not being paid for it. And if you do see a lot of board members that want to be paid for this service, then it might be more appropriate to have a for-profit corporation. Some tips for board members and retaining talented and productive board members is to develop clear expectations for board members. I know that's hard when you're a growing organization and you're not sure what kind of funding is coming in, and if you're capable of hiring a coordinator, but you want to be clear with what you expect from your board members. You want to have experience or expertise to be able to further a nonprofit's mission. A lot of people have a really well-intentioned cause when they want to start a nonprofit, but they might not have a board that has any experience in the field or in the mission statement or any Florida nonprofit experience. And it just may make sense for that board to either learn from another nonprofit first by serving on their board, or working with another nonprofit that's already established that has the same or similar mission, and at least get caught up before starting their own. You want to be cautious about the size of the board, because if the board is too small, there's going to be too much work for the board members to do. But if it's too large, it gets really difficult to get things done. So again, this is all going to be specific to what you envision for the nonprofit and what kind of work your nonprofit wants to accomplish. But those are just some tips that commonly come up for our clients. And then, of course, if you do obtain tax exempt status for your nonprofit, there are some major benefits. For a property tax exemption, nonprofits may be entitled to that for real property taxes on property used for charitable, educational, scientific, religious, and literary purposes, is the language from IRS and statute. So you can file for this exemption with the county property appraiser, and you must own the property as of January 1st, and then you refile each year by March 1st. Also, sales tax exemption, you register with the Department of Revenue and obtain a certificate of exemption if you're a tax exempt nonprofit. And then that also applies to commercial leases. So you won't pay sales tax on rent, which is a huge savings, and then goods and services used for the tax exempt purpose. So noticing that caveat that they have to be used for the tax exempt purpose. And finally, briefly touching on lobbying, which became a big point with our clients when Black Lives Matter was becoming a big movement and consumers were expecting nonprofits to speak up about it. We have to be careful with lobbying, but generally nonprofits can lobby. So nonprofits can lobby, but they cannot devote more than 5% of its activities and resources to lobbying. So it's really restricted. Or if the nonprofit makes a 501h election with IRS, it can lobby up to 20% of its activities and resources. So what constitutes lobbying doesn't have a great definition. Examples include contacting a member of a legislative body, so that could be reaching out to a local, state, or federal, or even international representative to propose, support, or oppose legislation. or urging the public to contact members of a legislative body to propose, support, or oppose legislation, or advocates for the adoption or rejection of legislation, or communicating with the general public and reflecting a view on a ballot initiative. So again, you can do these things, but very restricted, 5% with no election, or if you want to do 20%, you can do the 501H election with IRS. And it's still really tricky because, again, it's not clear how to define lobbying, but that's generally what we can condense it down to. However, we had to be clear that 501c3 organizations are absolutely prohibited from directly or indirectly participating in or intervening in any political activity on behalf of or in opposition to any candidates for elected public office. So you'll just want to be careful how you support a cause. You don't want to support a politician because they support a cause, but you may want to support that cause. And that's it for tips and information about the legalities of starting a new nonprofit. I also want to share resources that SCORE of Naples is a wonderful resource, and they have some counselors that have nonprofit experience that they may be able to assist. Of course, nonprofits are always looking for grants. So SCORE, the federal chapter, the overall chapter, does have great webinars on where to find grants regularly. And just really Google searching what your mission is and grants and seeing if anything comes up. And if you are interested in applying for our legal services for nonprofits, you can email Miss Sherry Despointes, and her email and phone number is on the screen. And if you have any questions, my name is Callhan Soldavini. I'm a staff attorney at Legal Aid Service of Collier and Broward County. I also work in the Florida Community Development Legal Project, where we provide these services for nonprofits. We also provide them for small businesses owned by low to moderate income individuals throughout the state of Florida. So if you have any questions, I'm going to remain on the line for a little longer if any come in. And if not, thank you all for tuning in, and I wish you the best of luck starting your new nonprofit.